This is your weekly fix. I'm Smitha Nair. Over the last several months, but particularly the last few weeks, news of a confrontation brewing between the Supreme Court and the government over the appointment of judges to the Apex Court and High Courts has frequently made the headlines. In the latest salvo by the government, the law minister has written to the Chief Justice asking that a government nominee be included in the Collegium that decides on these appointments. Now, the opposition Congress has charged that the government was intimidating the judiciary in a bid to capture it, and that it was deliberately delaying the appointment of judges to create a logjam till people favorable to its, quote, ideological masters are appointed. The Supreme Court has in the past, while acknowledging that the executive has a role to play in judicial appointments, clarified through judgments that the Collegium has the primacy in these appointments, which is to say that the Collegium's decision to reiterate names multiple times should result in those judges being appointed. Yet that hasn't always been the case. Now, into the mix is a renewed debate over what is called the basic structure doctrine. What is it? What's its significance? How exactly were judges appointed before the Collegium system was put in place? What even is the Collegium system? And importantly, why should you care? Senior Advocate Sanjoy Ghose has agreed to answer those questions for us. Thank you so much for making the time.
Thank you, Smitha, for having me.
Right. Mr. Ghose, I struggled a bit with where to start and wondered how far back one should go to sort of properly understand this hostility between the Supreme Court and the government, the executive, over judicial appointments and the implications of the judiciary potentially losing their primacy in matters of appointment and transfers. And the linear approach, I thought, will serve as best. And we will go as far back as when the basic structure doctrine first evolved, was first enunciated in the Keshwan Judgment. Can you, Mr. Ghose, begin by telling us exactly what is the basic structure of the Constitution and what were the circumstances that led to the Supreme Court propounding that basic structure doctrine?
I will. It's my pleasure, Smitha. But if you will permit me to go a little further back in history,
absolutely.
The confrontation between the judiciary and the executive is nothing new. In fact, as early as in the 50s, when the first Chief Justice of India, Harilal Kania, died, Justice, the successor Patanjali Shastri was not Nehru's favorite. He wanted to supersede him. And that's when the rest of the judges absolutely opposed it. When Patanjali Shastri went, the next person was Justice Mahajan, Meherchand Mahajan, who was the Chief Minister or Prime Minister of Kashmir and had many run-ins with Nehru, and Sardar Patel is to mediate every time. So Nehru didn't want Justice Mahajan to be the Chief Justice. All the other judges said that, I'm sorry, Prime Minister, then you'll have a different, then you need a new Supreme Court because we are all going to resign en masse. So that was that was a collective will of the judiciary to stand up to the executive for its independence. So just to say that, this executive and judiciary clashing has been much before. And in fact, this government, doesn't have a hostile court at all. If you see all the major judgments, demonetization, Central Vista, the mysterious death of Judge Loya, in most cases, these verdicts are in favor of the government. I'm not saying that the court is favoring the government, but the government has had no cause of complaint. And yet, of course, this government is in a hostile and agitationist path with the Supreme Court. Indira Gandhi, in contrast, had such a difficult court. Indira Gandhi hated Justice Shah. And of course, her apprehensions prove right, as you know, that when the Janata Party came to power, it was Justice Shah who was the Shah Commission inquiring into Indira Gandhi. So Indira Gandhi wanted to supersede Shah, did not work. Indira Gandhi then, of course, had to deal with the judgment of the Supreme Court in I.C. Golaknath's case, which is actually the precursor to Keshwananda Bharati, where in I.C. Golaknath, the Supreme Court said that you cannot at all amend, the Constitution of India in its Article 368 gives the power to the Parliament to amend the Constitution. So, I don't want to get too technical, but that is the constituent power as opposed to a normal legislative power. And this constituent power can be used by Parliament to amend the Constitution itself. Parliament, which is a creature of the Constitution, can amend the Constitution itself. Now, the issue was that can you amend even fundamental rights? So in IC Golaknath, the Supreme Court said no. It's a no, no. You can't amend the fundamental rights. And from then onwards, Indira Gandhi was determined that I need a different court. And more importantly, in the fundamental rights was the right to property. You know, all the fight was over that, because this government was a socialist government, or rather tried to show to the people they are socialist. So you had the abolition of privy purses, the bank nationalization, the land reform legislation. So everywhere, the Indira government wanted a committed judiciary. Committed judiciary means, of course, they meant committed to Indira Gandhi, the prime minister, but obviously they can't say that. So they said committed to the constitutional principle of socialism. Our party's manifesto says Congress is for socialism, Garibi Hatao. So we want a judiciary committed to that. So they went about systematically, Indira Gandhi went about systematically appointing judges so that one day they would be able to overturn this Golaknath judgment and say, yes, you can amend freely. And that is where Keshwan Bharati's judgment comes. So there were 13 judges of the Supreme Court, and this is one of the most important landmark judgments in constitutional law. 13 judges are sitting, and they are deciding, can the power to amend the constitution be used to amend anything and everything? For example, today, can I amend the constitution, declare India a Hindu Rashtra, or a Muslim Rashtra, or a Christian Rashtra? Can I amend the constitution today and say, instead of prime minister, we'll have a king? So that is what was before the court in Keshwananda. And of course, every judge, the government was actively lobbying to ensure that the verdict came in its favor. So, for example, Justice H.R. Gokhale, who was a law minister, was lobbying with Justice Gajendra Gatkar, who had just retired from the Supreme Court, but was a grandfather like Bhishma Pitama of Maharashtra, who was telling Justice Chandrachud that, you must rule in favor of the government. Then you had Justice Mukherjee from Bengal, then Siddharth Shankar Ray, who was part of Indira's kitchen cabinet working on the Bengali angle. Justice Beg, with Congress sympathies, was being worked upon. In fact, Justice Beg checked into a hospital in the middle of the hearing. And the hearing had to be completed by 24th, because 25th April 1973, Chief Justice Sikri was retiring. And then the entire process would become useless, because again, they'd be re-arguing. So they were rushing against time, and ultimately the judgment came and was confused because every person gave a different verdict. So then one person, that is Chief Justice, wrote down that this is the point of majority, and wrote down these are this is where the concept, coming to your point, this is where the concept of basic structure comes. The court comes out of the exclusive point in IC Golaknath that you can't touch fundamental rights. And it says, yes, you can touch fundamental rights, you can amend fundamental rights, but you cannot alter the basic structure of the Constitution, the foundation of the Constitution. What we consider as foundational pillars of the Constitution cannot be amended, even though the Constitution does not use the word basic structure, though the Constitution power of amendment in 368 does not have any ifs and buts, it's an absolute power of amendment. But the Supreme Court, reads into this the concept that basic structure can't be amended. So next question yours will be, what is basic structure? So the Supreme Court, there also, as I said, each judge in Keshwananda gave their own judgment. So, just to give you a taste of what Justice Sikri wrote, and I've written down, Justice Sikri said supremacy of the Constitution, republican and democratic form of government, secular character of the Constitution, separation of powers between executive and judiciary, federal character of the Constitution. These are like basic structure. All the judges said, I am just giving a list of illustration. No one said a basic structure is A, B, C, D, E and nothing else. So each of them said, these are like illustrations. Justice Shelat and Grover said, unity and integrity of nation is part of basic structure. For example, Justice Hegde and Mukherjee said sovereignty of India is basic structure. Then the democratic character is basic structure. So tomorrow you can't amend the Constitution and say कि हमें elections और नहीं चाहिए. We will only have the present Prime Minister as a leader of the government till he dies. So you can't do that, because that amendment, Supreme Court in Keshwananda Bharati says, is against the basic structure of the Constitution. So this is to give you of course, the day this judgment was pronounced, all those judges who held, 3 of the judges who held in favor of basic structure were superseded by Indira Gandhi, and Justice A.N. Ray was appointed as Chief Justice, who was in favor of the government, holding government has unlimited power of amendment.
All right, got it. You sort of have answered much of what I wanted to ask you, even in subsequent questions. Even so, there are some specifics. Perhaps I can get clarity going forward. For our viewers, some of what Mr. Ghosh has said, the gist of it is this is why it becomes relevant who these men and women are, these judges who will have the power to keep a check on the executive, the government, and therefore who appoints these judges becomes important. Can we, for a moment, Mr. Ghosh, focus on this collegium system of appointment of judges? And could you sort of explain to our viewers what sort of a system existed pre the evolution of the collegium system? You've already spoken about the Indira Gandhi regime and attempts being made by the Indira Gandhi administration to have a committed judiciary or to pack the court with judges that are perhaps more amenable to her administration and her point of view. So the pre-collegium system and how sort of collegium came about.
Right. Now, here also I have to give you a crash course or share with your viewers a crash course in the collegium history. Incidentally, before you always had the system of consultation. Okay. Now, nowhere in again, as basic structure, nowhere in the constitution is the word collegium used. Okay. So this is also an judicial invention, collegium, like basic structure. There was consultation. The word used in the constitution is consult, that the president will consult the chief justice. Now, what happened is there were what we call the three judges case. There was a case in 1981, which was called the SP Gupta versus Union of India, which is now known as the first judges case. The second was in 1993, which is the most important of these, the series of judges cases, which is called the Supreme Court Advocates Association on Record Association, Sakora versus Union of India. And then ultimately there was a presidential reference, and there was another judges case when Justice Punchi was Chief Justice, which is in 1998, which is called the third judges case. Now, why did this come? In the first judges case, the Supreme Court was very clear that no, the primacy of appointment rests with the executive. The judges, the judiciary can only make suggestions, recommendations, then the executive will decide. In the second judges case, this power was judicially usurped, if I may use this term usurpation. The Supreme Court now says that, look, consultation in Articles 217, 124, which deal with appointment to High Court and Supreme Court judges, the word consultation means binding consultation. Now, what does binding consultation mean? Binding means when I give you a suggestion, you can't wriggle out of it. You have to accept that suggestion. So what the Supreme Court does in the second judges case, I said first one was in 1981. There the Supreme Court accepted that, okay, executive is the real person to appoint. But in the second judges case in 1993, the Supreme Court says, no, we are the ones who will suggest to you. And of course, the Supreme Court loosely says that two senior most judges will consult each other, Chief Justice and the J1, as we say, the senior most judge. Now, there were certain other issues with regard to judicial appointments. It is always simmering. Every few years, this issue simmers and comes up in the public domain or in the constitutional domain. So again, in 1998, the Supreme Court visits this issue. And this time, the Supreme Court comes up with the concept of collegium for the first time and says it shall be the Chief Justice and two senior most judges of the Supreme Court. For appointment of Supreme Court judges, it is 5 senior most judges, and that is the Chief Justice and 4 senior most judges. So this becomes the collegium for appointment of High Court judges and collegium for appointment of Supreme Court judges. So now the system is that the judges themselves originate the name, and then that name goes to the executive for vetting. IB check, income tax check of the candidates, etc., is done. The executive then gives its report or its recommendation on each candidate, who's proposed for judgeship, to the collegium, the Supreme Court collegium, and the judges sit. And as you know, there was, this whole process was like election of pope. At least there is some kind of, canonical rules. Collegium had no canonical rules. So there was no voting and white smoke and black smoke for the Collegium meeting. It was very mysterious. Of course, it was like the judges meeting in secrecy, deciding in secrecy. And ultimately, the Collegium would decide and make a recommendation to the executive. Now, the Supreme Court judges case, the three judges case read together, that's basically the third judges case, says that the government may disagree with the recommendation. So let us say the Supreme Court has recommended Smitha's name as a judge. But the government then says, look, sir, sends back a letter to the Supreme Court saying, look, sir, Smitha has been working in Scroll, and Scroll has been carrying very, anti-national articles and all that. So please don't appoint Smitha as a judge. Now, the Collegium has an option. Collegium can say, okay, government has given us this value, very important point. We didn't know Smitha was indulging in all these, anti-national activities. So we will not make Smitha a judge. Or the government may, the Collegium may say, what nonsense is this? Smitha is a lawyer and she's also part-time working on legal journalism with Scroll and writing very good informative articles to explain law to people. So we don't accept this, this stupid objection. I am reiterating the recommendations. Please make Smitha a judge. So the third judge's case says that moment the Collegium sends back and reiterates a recommendation, that is binding on the government, and government has no choice but to appoint that person. But sadly, what is happening in the last 4-5 years, even on a reiteration, the government first sits on that name for months, if not years, and then sends it back again to the Supreme Court. And sadly, the Supreme Court has not been taking the government to task, saying, how dare you violate the judge's case, and how dare you not appoint the reiterated names? And that is why we are in a situation today where you have the vice president and the law minister who's been saying all these things that have been said, which is contrary to the law laid down by the Supreme Court.
The other sort of bit of jargon that we hear about, and our viewers no doubt have come across it as well. What is this memorandum of? I'm sorry.
I'm sorry. I was having coffee. I hope that is permitted.
That's all right. What is this memorandum of procedure, Mr. Ghose, that we hear about, and what is it to do with the Collegium system of appointment?
Yes. So, what happened was that this three judges case was not acceptable to most political parties because they felt that, we politicians should appoint judges. And rightly so. They may have felt that, Constitution gave the politicians the primacy to appoint judges. And they have a point because, you see, judges are the only unelected wing of the government. Whereas the ministers and parliamentarians have to go back to the people. Ministers are accountable to the people. People are accountable to, the MPs, and the MPs are accountable to people. But the judges are unelected. They're not accountable to anyone. They can be only removed by impeachment. So the 2 points where there is a constitutional control was one at the stage of appointment, and the other is at the stage of removal, that impeachment. Now, the Supreme Court has done a nice number. When it comes to appointment, Supreme Court has taken over the power by saying that, no, we will recommend to you and is binding on you. And in the stage of removal also, Supreme Court has now taken over the power by saying, even if we impeach, we can judicially review it and say, it's bakwas. So your resolution is wrong, our judge will stay. So in one way, the Supreme Court has taken away the oversight of the parliament in removal and executive in appointment on the judges. So what all political parties had the same view at that time. Let's be very clear that at that time in 2014, when the NJAC bill was being deliberated, all political parties were on board. Unanimously, they all said that, judges can't be appointing judges. So that's how you had the NJAC bill, which amended the Constitution, introduced Article 240A, 124A, 124B, 124C, and put in place this NJAC, National Judicial Accountability Appointments Commission. And this NJAC would have the Chief Justice and 2 senior-most judges, the law minister, and then the leader of the opposition and 2 eminent jurists. Now, this was challenged constitutionally, as you are aware, and the Supreme Court struck down by a majority of 4:1. Justice Chalameshwar was the dissent. Supreme Court struck down this as violating basic structure of judicial independence, relating again to your basic structure and judicial appointments. So there is a method in the madness, Smitha, as you see, why all of a sudden they're talking about basic structure, why they're talking about NJC. So there's a method in the madness. It's not randomly that these thoughts are being put out by the constitutional functionaries in the public domain. Now, cutting a long story short, when the NJC hearing was winding up, the court had told the parties that, both of you can make suggestions and we can have a memorandum of procedure, like a loose guidelines of how to appoint. And the NJC judgment notes that neither party took it seriously. No one gave a memorandum of procedure. But where it went wrong was it actually said we now direct parties. Basically, parties means what? The Supreme Court and the government to sit together and formulate a memorandum of procedure. So that memorandum of procedure from the NJC judgment, till date, from NJC judgment came on 16th of October 2015. Now, from 2015 till 2023 January that we are, neither party has been able to formulate the memorandum of procedure. So one of the things talked about in the memorandum of procedure was this thing that there'll be a search committee. So that's how Kiran Rijiju is saying that, look, when I told you, the Chief Justice, that please have government representative, I didn't mean in the Collegium. I meant you have it in the search committee because the memorandum of procedure also talked about it. So very selectively, you are not going to follow the law, the judge's case, which said that you have to bindingly appoint. You frustrate judicial appointments by sitting on the files for months and years. And then even reiterated recommendations, you sit for months and years, and very good lawyers who actually give their names withdraw their consent. Justice Kaul observed in the Supreme Court that I know very good lawyers who gave their name, and then because you sat over their appointment because they had given some speech against the CAA or NRC, and you didn't want them appointed because you only want those people who will only say government is good and everything is bad. Therefore, those people withdrew their names. They said, I don't want to be a judge. So very selectively you will follow the law, and we will disobey the law. And very selectively you say, now I want to follow the law. I want to give recommendations for us to have government nominees in search committees. But the question is that why haven't you formulated? You are saying you're doing it in terms of memorandum of procedure, but you have not even formulated the memorandum of procedure from 2015 till 2023. Why has it not been done till now?
Okay. I get a sense that you're, correct me if I'm wrong, you're saying that the Collegium system is not necessarily the best. There is still a level of opacity involved in how the Collegium system functions. I wonder if you could independently sort of comment on what you thought of the NJAC. What did you think of the sort of mechanism that the Parliament passed and, of course, subsequently, as you rightly pointed out, was struck down?
See, I will share with you. See, I'm a person, if you know me in the public domain, I never hold back my punches. So I will speak as very few people actually speak. So let me tell you this, my personal view on the Collegium system and the NJSC was I was a big avid supporter of NJSC because I've always believed that the Constitution, as I told you, the power of appointment, the check is of the government, power of removal, check is of the Parliament. Otherwise, judiciary becomes an unaccountable person. It has, as of today, it has taken over the power of appointment. It has taken over the power of removal also. But, not that I have any sympathies for the opposition, because I believe all politicians are the same. But today I'm in the same predicament as the opposition because we are stuck between the devil and the deep blue sea. If the government in the last 8 years, this present government, had shown a modicum of judicial decency, constitutional decency in the matters of judicial appointment, I'm not making a political comment. I'm only commenting as a legal scholar on the constitutional propriety in the matter of judicial appointments. That's all. If the government had shown bona fide good faith in these matters, I would have definitely said that yes, the government is right. But today I see that the Collegium system with all its flaws is still some kind of check against a majoritarian government like this. So therefore, my point is that though, and it's a hypocritical point and I'm confessing, though I believe that the Collegium system is wrong and the Collegium system has a lot of flaws. In fact, we have had great jurists appointed outside the Collegium system. In fact, most of the great jurists of India, Hidayatullah, Chandrachud, the senior, Justice, Patanjali Shastri, Chinappa Reddy, Subbarao, all the great jurists have come through the old system. In this new system, why did the Supreme Court come up with this new system? The Supreme Court wanted to insulate the power of judicial appointment, to have merit, to have people who were independent, to have people who were competent, to have people who would not cow down to the government or the political party in power. But what has happened is that, in effect, in the collegium system also, the Supreme Court has always been there is this tendency to I scratch my back and you scratch my back. So the judges in the collegium have also said, two of my nominees, two of your nominees. And when it comes to a competent judge, the whole collegium system was to insulate the whole appointment. But look at what happened with Justice Qureshi's appointment. Just because he had passed certain orders which certain politicians did not like, and they had to face incarceration because of that, when these politicians came to power, they ensured that this very competent judge did not come to the Supreme Court. Of course, Justice Rohington Nariman, took this stand, and he basically completely, paralyzed the functioning of the collegium during Justice Bobde's time on the principal issue, and I salute him for that, on the principal issue that why should Justice Qureshi be superseded. But that is not a solution, because ultimately you did nothing. The moment you retired, the next day they had a meeting, they removed Qureshi and appointed other people and brought some lady members to the Supreme Court, and focus was on that, okay, see, we have brought so many women. And the press and everyone bought that, sweet pill that, see, women have been brought to the Supreme Court, forgetting that you have also sacrificed a minority judge only because it was unsuitable for the executive.
Right. Mr. Ghosh, of course, is referring to Justice Qureshi's orders in the Sharabuddin Sheikh fake encounter case, in which the current Home Minister and then Gujarat Home Minister, Mr. Amit Shah, was charged. Mr. Ghosh, I want to close by reading a sentence from that excellent piece you wrote in Live Law, and I'll try and link to it below here as well. You end that by saying, I am therefore optimistic that the basic structure is here to stay. However, do remember that Oscar Wilde has said, the basis of optimism is sheer terror. Is it indeed sheer terror of what would happen if all this were to unravel that makes you believe that it will not?
Smitha, not that I'm a big fan of the Chinese people, but there's an ancient Chinese curse. May you live in interesting times. And none of us can dispute that we are living in very, very interesting times, and it is a curse.
All right. On that note, Mr. Ghosh, I appreciate your time and your sort of very animated and story-like sort of description of how this system of appointment of judges has played out right from the 50s to what we're seeing play out in 2023. I hope it's aided the understanding of our viewers as well. Thank you so much for your time.
Thank you so much, Smitha.
Thank you.